Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. We'll begin with Higgins versus Wilson Air and Mr. Bryant.
May it please the court, I'm attorney Ralph Bryant, Jr. This case arises out of the Western District of North Carolina. We're here on appeal of a summary judgment order entered on December 1st, 2023 by the Honorable Judge Conrad. The nature of this case is it is an employment discrimination case. My client alleges that the defendant, Wilson Air, discriminated against her because of her disability. She is a cancer survivor, and as I'll talk to you about in just a second, she's survived a double mastectomy. So the facts of this case center around about a 36-day period of time, from May 11th, 2021 to June 17th, 2021. And so leading up to May 11th, 2021, my client started working for Wilson Air, and she'd been working in 2005. She'd been working there about 16 years. During COVID, about March 20, COVID was around that period of time, she was diagnosed with cancer. About a year before this May 11th period of time, she was diagnosed with cancer. COVID came along, and because of COVID, they had her working remotely from home. She worked from home first because of COVID, and then she had a double mastectomy in September 20. She had a double mastectomy in September 2020. She continued to work from home. Then in January, she had to have some chemotherapy infusion treatments. She continued to work from home. And during this entire period of time, she actually performed all the duties of her position. She was able to perform them remotely.
And then on May, I think we're fairly familiar with the facts, but so I wanted to skip ahead to a question about the facts.
Okay.
On May 11th, she and her employer had a meeting in which it appears she agreed to a reasonable accommodation. And did she not then reject that by failing to abide by it on the 17th?
No.
The reasonable accommodation being that she would start Monday at 7, and then that Monday would be May 17th, and see where it goes, and she responded, okay. In fact, they suggested that she could be in the office one day a week to get the work done that she needed to get done in the office, and she said, I can do it twice a week. So how did she not reject that reasonable accommodation?
So what happened, and they had the meeting May 11th, and during the May 11th meeting, they agreed that the reasonable accommodation would be that she could perform the duties of the position from home and some of the duties there at work. On May 12th, the next day, she contacted the human resources person for Wilson Air and said, they're demanding that I come in. I'm not sure what my doctor is going to say about this. I've got to talk to my doctor. And she got a note from her doctor that came in May 17th saying that the doctor wanted her to continue to work from home because of her compromised nature.
But she didn't tell them all that at the meeting that they had on May 11th, right?
Two things. She told them that she would have to talk to her doctor, and she told them that her health and her life was most important. And when she left, she told them, I will talk to my doctor and I will get back with you. But other things aside, if the doctor does not object to it, I will be here on the 17th. The thing is, on the 12th, she continued to engage in protected activity when she contacted the HR person.
Your opponent suggests that between May 11th and June 18th, she only worked in person 2 partial days total. Now that's a very minimal period of time, and the opposing counsel has listed all kinds of events all kinds of tasks that needed to be performed in the office. But you only came to the office in over a month for 2 partial days, and yet there are all these tasks that must be performed in the office. And so your client is a no-show, and don't we have some law indicating that if you're a no-show, essentially, you're not a qualified employee?
Your Honor, and so the facts that the audio recording, the transcribed audio recording, clearly shows that she was performing all of the duties of her position. The people that work there clearly reached the conclusion you are performing all of the duties. The payables that opposing counsel talked about, they talked about it in there.
But to follow up on what Judge Thacker said, this is a company, this is not a really harsh employer. They tried to offer one reasonable accommodation after another. At first, it seemed that those were accepted, but then as the performance played out, in actuality, they were rejected. But the company here is searching for reasonable accommodations here. And nothing ever seems to work. And it's compounded by the fact that they're having a great deal of difficulty finding out why she was a no-show. There was not the kind of communication that one would expect from someone when they're absent from work. They make calls and everything. So what you're dealing with here is a company that tries a variety of reasonable accommodations. They don't work. The individual doesn't show up for work. The individual doesn't communicate properly why she didn't show up for work. We have precedent saying that, and of course one has to be qualified employee. We have precedent saying that if you are a no-show, you're not a qualified employee. And so I don't understand what Judge Conrad did wrong here, given this record.
Yeah, Your Honor, just so when you look at what actually occurred on the 12th, after the meeting, on the 12th, when she spoke to the human resources officer, she was engaging more in her right to protected activity to say, hey, my doctor may not allow me to return to work. And she got a note from her doctor on May.
I don't think anybody really contests that she was in protected activity most, if not all the time along the way. But, and I'm very sympathetic to her client. I'm a cancer survivor, so I can understand that. But this really strikes me as a case almost of no good deed goes unpunished. It seems like this is an employer who went out of its way in a lot of different ways to accommodate the claimant. And I think your burden is to explain why all of the times where the claimant didn't show up, she didn't answer phone calls, she didn't answer emails, why that doesn't entitle the employer to terminate the employment.
Thank you. So May 17th, when she didn't show up, she did not show up because she was waiting to hear back from the HR person. She specifically told her, look, I'm gonna talk to Vince Papke, who is the general manager, and I will get back with you. When the HR person called her again, it was May 25th, the next week, and she said to her, you have to be at work the next day. And the next day, even though she had 2 medical appointments, my client actually went to work the next day. That was the 26th. On the 27th, which was a Thursday, they understood that she always had that chemotherapy infusion every third Thursday, so she went to chemotherapy like they all agreed. Friday, she didn't work because of an agreement they reached during COVID. Saturday and Sunday, Monday was a holiday, the 31st. The next day she could possibly work was actually June 1st, and she showed up on June 1st and actually worked that day, even though while she was working, The expander broke, and she had fluid coming out her shirt. She actually finished the day. The next day, she had a medical appointment, and during the medical appointment, the doctor, that's when the doctor said, I'm gonna put you in emergency surgery the next day, and the doctor sent the employer a note telling them she will be out of work from June 3rd until June 17th, and they fired her on June 17th. So
But I don't know so much if it's the out of work then, but it's the failure to communicate. Because she would get emails or phone calls from the folks at Wilson Air and just didn't communicate back to them. She may have had some misunderstanding, but what's the employer to do in that circumstance? They're trying to communicate, they're trying to accommodate, and they don't get anything.
So what happened is, she did communicate. On the 4th, she communicated with the general manager, Mr. Papke, who asked her about the surgery. She told him it went well. On June the 6th, she communicated with her supervisor. He sent her a confirming text message on the 7th, and she said, look, the doctor wants me to be out for the surgery. I'm gonna take my leave, since you're not gonna let me work, I'm gonna take my leave until I get an opportunity to come back. She did communicate that directly with her supervisor. What you were hearing about from defense counsel is that they took her work laptop. So instead of them being able to communicate through MS Teams like they'd done for years, now her supervisor texts her cell phone, the general manager texts her phone. These two ladies, Ms. Case and Ms. Bond, they start sending something to her private email that she wasn't checking for things from them because she had already given them a note that she was going to be out to the 17th. And so it wasn't a thing of her not communicating. She clearly communicated with everybody. It's just this one issue with these two ladies who kept trying to, while they had a note, they kept trying to get at her about you not coming to
So
work.
it sounds like your argument, at least with regard to this part of the case, might be that since this is a summary judgment dismissal, there is a genuine issue of material fact as to this communication issue.
Yes, ma'am. Yes, ma'am. That is the issue in this appeal, is that a jury should decide this. I mean, there are a lot of things. For instance, when I took Miss Emily Cates' deposition, there was a certain amount of tenseness, a certain amount of aggravation in her voice that if a jury could hear, they could say, well, why are you so aggravated with this lady who had breast cancer trying to come back and forth to work? Those are the things that I think that a jury is entitled to make decisions about. And that's what we're asking, that you return it and allow a jury to make those decisions. And then the defendant, even when they're talking about the dismissal of certain claims, they're saying she's not a qualified individual. She certainly is. And they have not said anything about undue hardship. The recent Supreme Court case says, look, if you're going to say that you cannot accommodate them, then you have to move forward with some sort of undue hardship. They have not once even talked about any type of undue hardship. In fact, they really can't, because they transcribed the meeting, and the words of the meeting really control. And during the meeting, over and over, her supervisor said she is doing everything that we need done. And so then
let me ask you about this testimony from Bond about an email. And she's communicating to Ms. Higgins, I sent you an email on Tuesday the 8th because you did not show up for work and we did not hear from you. We knew you were going to be out of work on the 7th, but we did not have any notice that you would be out for multiple days. We just received a note from your doctor saying you need to be out until next Thursday. When you expect to miss multiple days, you need to let us know in advance. Please contact me on Wednesday next week so that we can plan for your return. And then the district court concluded, again, Higgins answered with silence. Is there any factual dispute about any of that?
Yes, Your Honor.
All right, what is it?
Is that on June 6th and 7th, she communicated with her supervisor and advised her supervisor that she would be out of work. The other issue is this communication this communication is communication through a private, well, they had taken her laptop. And so when they used to communicate through MS Teams up until that moment on June 2nd, when they took her laptop, they always communicated through MS Teams. Now they start communicating through a private email that she's going through chemotherapy and she's going through surgery. She's not checking her private email every day. She had already talked to her supervisor, John Cox, and he knew she was gonna be out.
That's not really a factual dispute. It sounds more to me like that's some sort of a defense that you would offer.
That, yeah, sure, okay, so what the defendant is saying is that, the defendant is saying that these two ladies communicated with her, and my position is they didn't, and they knew they weren't communicating with her, and that statement that she made, that in that letter, in the email, that my client had not communicated with, they knew it was false because she communicated with her supervisor. And it's a situation where these two ladies got upset with my client and
And when you
decided to
say
terminate.
she communicated with her supervisor, you're talking about the June 6th text?
Yes, ma'am, June 6th and June 7th when he replied. And so the issue is that these two ladies acting on her behalf decided to terminate my client. There is not in there an affidavit or deposition testimony from John Cox, the supervisor. Everything you know about from John Cox, the supervisor, says in that May 11th meeting, oh, yes, she does that already. Payable, she does that already. Yeah, we can get it done. We can get it done. Nothing that amounts to termination. And why would you terminate a lady? Why would you terminate? I guess I need to give my time. Why would you terminate someone who actually has given you a doctor's note to cover those days, and on top of that, still has sick leave and personal
Well,
leave?
when did the doctor's note come in?
Doctor's note came in, I think, on the 10th.
Right,
And-
okay.
And she said, in her deposition, she said, look, I had the doctor's note. I knew those days would cover from the 3rd through the 17th. When we terminated, we knew those days were covered. All right,
Thank you, counsel.
thank you, Your Honor.
Mr. Das?
Good morning, Your Honors. May it please the court. My name is Proloy K. Das. I'm joined by my law partner, Frank L. Day. We're attorneys of the law firm of Ford Harrison. We're here today on behalf of the defendant appellee, Wilson Air. Your Honors, as a legal matter, I think I'd like to just start with qualified individual, because I think that's dispositive of both the discrimination and accommodation claims. And the reason for that is when someone brings an ADA claim,
Can you get that microphone as close as possible to you?
when a plaintiff brings an ADA claim, they need to show that they're a qualified individual who can perform the essential functions of the job of the specific employment position at issue. Here we're talking about the accounting assistant position. Now, the question about what are essential functions for a particular position is not an objective question. It's a question for the employer to determine. And the employer determines that from the very first job description. So what happens here is you have the employer determining that this job requires individuals to be in person because the way this particular employer processes their payables requires that in-person presence. And on pages 11 through 13 of our brief, we've set that process out. Now, once that becomes an essential function, in order for an ADA claim to be brought, the plaintiff has to be capable of fulfilling those essential functions. The starting point for that is the job description under both our regulations and our case law, and I refer the court on page 19 of our brief to Hannah v. UPS. The job description here is Exhibit 10 of our summary judgment papers. It's in our joint appendix at 249. Within that job description, it makes it very clear that the position of accounting assistant has to maintain the paper files, has to maintain the files for the payables, has to process the checks. All the processes that the judge found to be necessary for in-person presence on page 2 of his decision, on page 9 of his decision, are things that require the individual to be in person. Now, the ADA doesn't require that the employer change those essential functions. So in this case, when the employer determined that the essential functions required the individual to be in person, that if the plaintiff concedes that they're not able to do that, then they can't bring an ADA claim. And if you look at, that's what the judge determined here, if you look at page 10 of the decision, footnote 1, summarizes all those cases, both in the Fourth Circuit and other circuits, that is the law. So once an individual can't satisfy those essential functions, the ADA simply does not apply. On that basis, that resolves both the discrimination claim and the accommodation claim because there simply is no ADA claim available. Now, the judge went a little further here, and in the alternative noted that not only the plaintiff not show that, she could satisfy the essential functions of the job, also could not show causation. Because, again, the burden on the plaintiff is to show that there is causation between the adverse action and discrimination. And that's not what we have here. The judge noted there's no direct or indirect evidence presented with respect to that. It's not enough just to challenge and claim that you disagree with the rationale the employer provides. They have to show causation in order to establish a prima facie case. Now, that, like I said, it's not particularly relevant to resolving the first two claims, the accommodation, disability, and discrimination claims, because again, those get resolved on qualified individual. But they are relevant to the retaliation claim, because although I think the case law is clear that once they couldn't establish that the plaintiff could fulfill all the essential functions of the job, they can't fit within the ADA, that doesn't resolve the retaliation claim. But the causation issue does. For purposes of causation, the plaintiff had to show that there was a direct nexus between the adverse action and a claim of retaliation for exercising a protected activity. And again, as the judge noted here, there's simply no evidence, direct or indirect, to establish that. So I think that's probably the most straightforward way to resolve this case. I think the most
So
important.
opposing counsel makes the point with regard to pretext that there's a factual dispute to be resolved over the plaintiff's failure to communicate. And he, as I understand the argument, says that she communicated on one date and then received various messages on her private email or private cell phone text, and that because of that, there's a factual dispute over that issue. What's your response to that argument?
So I think I'll go back to what the trial judge said.
That's what I understand the argument.
And I agree. They're trying to create a factual question about whether the individual was being disciplined, but that's not what happened here. And the judge said that's not an accurate representation of the reason for termination. And this is why I think, consistent with the first part of the analysis, the reason the individual was terminated was because they couldn't complete the essential functions of the job which required the individual to be in the office. That's evidenced by the fact that there was no communication, there were 3 consecutive days of absences, but all of that goes to the motivation being this individual could not complete the essential functions of the job, which required her to be in person. Once that was established, then as a matter of law, the claim fails. Now, if the plaintiff could show that there was some kind of motivation that was pretextual, and the rationale for being terminated was not because of the inability to perform the essential functions, but rather just the mere absences and the lack of communication. If that's what all this was, possibly. I still think the judge read it reasonably and said, I don't see a reasonable dispute of material fact. But the simplest way to resolve this, consistent, I think this is why the judge started with essential function, is to say this job required an individual to be in person. And the individual here did not come in person. And as a court, no courts are allowed to question the employer's determination of essential function because it interrupts the employer's business judgment. And that's why we don't invade what the employer determines is necessary. So in this case, when she was unable to come to work to do the job in person, which is what this particular employer requires for payable processing, the employer simply, there's simply no has every right to terminate that employee, and there's simply no violation either of the ADA or retaliation.
The employer here, the record is replete with examples where the employer is trying to make things work. There's been one accommodation after another that was suggested, and simply most of the accommodations revolved around the idea that you can come in and for a limited time, as long as you come in for, as long as you're there some of the time. And so these hybrid situations were suggested by the employer, which involved a combination of in-person work and remote work. And suggestion after suggestion was made. But none of these things worked out, but it isn't for an employer's lack of trying. They tried to make it work. And they were confronted with a difficult situation, as Judge Thacker pointed out. Certain accommodations appeared to have been accepted, and then they weren't in practice. And it boils down, it seems to me, to a simple thing, and that is that you have to be at work, if not full-time, a decent percentage of the time in order to do, and it's not just dealing with the accounts receivable. There are other tasks that needed to be performed in person. And despite the employer's best efforts, those qualifications were not met. And under our case law, you have to, in order to establish a Rehabilitation Act claim, you have to be qualified. And that basic threshold was not crossed. She just wasn't able to come, or she did not come to work, and it was critical. As I was saying, that's not only it's not only dealing with the accounts receivable in the office. She had to take mailed invoices. She had to print purchase orders. She had to collate paper checks. She had to prepare envelopes and mail. She had to file different payment packets. But there are a whole string of tasks that the employer determined were necessary for at least some time in the office. And they tried to make a go of it. And it never got off the ground, but it wasn't for lack of trying. This is not a harsh defendant. The record suggests plainly that this was anything but a harsh defendant.
Yes, Judge Wilkinson, agree with you. The employer tried to make a reasonable accommodation to perform the essential function of the job. That was not, complied with. And one thing, I think what they're trying to argue is that the employer should have just eliminated the essential function. But on page 18 of our brief, you'll see that's not the law. The employer here tried to make a reasonable accommodation so she could complete the essential functions, and the employee either was incapable or unwilling to do that. And I think that's the reason the judge rejected the plaintiff's claims. I'm happy to answer any additional questions, or otherwise we just ask that the decision below be affirmed.
We don't have any questions.
Thank you, Your Honors.
Mr. Bryant, you've got some rebuttal time.
Thank you.
Mr. Bryant, why don't you give us what you think is your best example of what you consider a material dispute of fact that would bar summary judgment here? What do you think is your best argument here?
Yes, sir. The transcript from the May 11th hearing, the defense counsel and talks about the job description and all this other stuff. But in the reality, the question is, what were the actual job duties, and was she able to perform the essential duties of the job? And
You mean the May 11th meeting?
Yeah, yes.
Yeah,
yes, ma'am.
you said May 11th hearing. That
I'm sorry.
confused me for a second, but okay, the meeting.
And then, and on page 7 of the brief, it's John Cox, who, again, there's no affidavit, no deposition testimony from John Cox that says she could not do this position. And he says, we were talking about what exactly, so basically everything.
I thought other people in the office, at least during COVID, picked up some of these duties, that they had extra duties because of this.
Your Honor, that's not what they testified to. That's not what they talked about during this May 11th meeting.
But Mr. Cox did cover some of the extra duties, right?
That is what the defendant is, that's what the defendant is saying. And when you.
Well, who work needed to be performed in the office? Going to the transcript that you're talking about of the May 11th meeting, it appears to me that appellant agreed that some things, like the filing, would need to be performed in the office, and that she said she could do that twice a week.
Yes, Your Honor, and John Cox also.
And that's
said-
at JA 211.
Yes, ma'am. John Cox also said, you know, you've done that before, I get somebody to do that, you know, but another.
Right, so that goes to what Judge Agee said, that they were getting other people to cover some of her work when she was out.
And so we're talking about the essential functions of the position as an accounting assistant, you know, versus every possible thing that they had in the job description. And essential functions, I think they.
And you're saying that filing is not an essential function of that?
Yes, ma'am. In their meeting, they talk about filing was not an essential function of it.
And
then-
what JA site should I look to for that?
JA 211. And then JA 215, JA 307. And again, I'm on page 7 and 8 of my brief. And I do want to mention that during the hearing, opposing counsel admitted that they transferred all these duties to Memphis, Tennessee from Charlotte. So the duties she was doing, they didn't hire somebody to do those duties. They transferred them to Memphis, Tennessee. And if they have to be done in person, as they say, the essential function has to be done in person, how can it be done from Memphis, Tennessee? And those are the things that a jury has to take into consideration when they're talking about, you know, they had to have her in office because of productivity. Well, they didn't hire anybody to replace her. And the person that they say they did hire, they hired them part-time. And they took her laptop from her. So productivity cannot really be, productivity has to be a pretextual reason. I think any jury would look at that and say, hey, this doesn't make any sense. You're saying you need her to be in the office because of productivity reasons. You're taking a laptop so she can't do anything now. How does that make any sense?
Well, Mr. Bryant, just to go back one step, you'd given Judge Stacker the site of JA 211. I believe Ms. Higgins is saying, I don't have a problem with filing, but I'll have to be here to do that part.
Yes, sir. And then John Cox says, well, you have done it before. We can get somebody to do that. Yeah, but like the payables and stuff, that's easy. It's usually once a week. I can do it twice a week. And then if you'll see throughout there, John Cox, it says, John Cox says, retail payables, filing international files. She said, I already do that. And John Cox says, yes, she already does that. And throughout their meeting, if you look at their meeting as opposed to this job description, look at their meeting, it's clear that she was performing the essential functions of the position. And I will say, if I can, before I go.
All right, and she says that she has to be in the office to do the filing and that she can do it twice a week.
Yes, ma'am. Yes, ma'am. And she agreed to that. The thing, I think part of what's being lost is the fact that the only reason she was not in the office was because of a medical reason, and she had sick leave, and she had a personal leave to cover that. Thank you, Your Honor. Thank you.
Thank you, counsel. We'll come down and greet counsel and move into a second case.
sat down.
I'm sorry, I can't hear.
There were folks in the audience who were waiting for you to tell them to sit down, but they sat down now.
Okay. All right, United States v. Brandon. Mr. Macbeth?
Thank
Whenever
you.
you're ready.
Thank you. Good morning, Your Honors. My name is Cullen Macbeth, and I represent the appellant, Michael Brandon. Your Honors, the government argued below that Officer Stewart lawfully stopped Mr. Brandon's car because he had reasonable suspicion that the car was in violation of Maryland's tint statute, Section 22-406 of the Transportation Article. That statute is identical in all material respects to the South Carolina tint statute at issue in this court's opinion in United States v. Johnson. That South Carolina statute applied only to cars required to be registered in South Carolina.
I thought he was also having difficulty verifying the registration. Is that correct?
So the officer ran the tag through the NCIC database, learned that the tag was validly registered to a dealership in Pennsylvania, but couldn't associate the tag with the car. So he couldn't tell whether the tag was registered to the car, but the tag was validly registered to the dealership.
So why wouldn't that be reasonable suspicion? I mean, it's a factual circumstance that's different than Johnson, may not be dispositive, but it doesn't seem unreasonable to me that a police officer would want to verify the registration that he couldn't attach to a vehicle. May be wrong about it, but I don't know that that's necessarily unreasonable.
Well, because the tint statute just does not depend, the applicability of the tint statute just does not depend in any way on whether the vehicle is registered or unregistered, or registered validly in another state. The only fact on which the tint statute depends is whether the car is registered in Maryland. And if it's not, then the statute just does not apply, period. Now, the registration.
So it would have, a vehicle in Maryland, in your view, would have to have a Maryland plate on it in order for the stop to be valid.
Or if the officer had some other basis to believe the car was registered in Maryland. But one way or the other, the officer has to have reasonable suspicion.
What happens if it's a car driving with no plates?
Well, then there's a statute that says cars have to have plates on them, so it would be a violation of that statute, but it wouldn't necessarily be a violation of the tint statute because, again, there's no reason to believe that car is registered in Maryland. Perhaps the car should be registered in Maryland, in which case it would be a violation of the statute that requires cars to be registered in Maryland, unless an exception applies, but it wouldn't be a violation of the tint statute. The tint statute requires that the car be registered in Maryland, and so unless there's reason to believe the car is actually registered in Maryland, the statute just doesn't apply. And that really is materially identical to what was at issue in Johnson, where the car the statute applied if the car was required to be registered. And there just was no evidence that it was required to be registered, and for that reason, the tint statute in Johnson did not apply. Here, the car had a Pennsylvania plate, so not only was there no reason to believe the car was registered in Maryland, but there was affirmative reason to believe it was not registered in Maryland because it had an out-of-state plate. And so under the logic of Johnson, the tint statute just did not apply to that car. I think the question then becomes, does the good faith exception apply based on the Court of Special Appeals opinion in Baez? And we submit that it does not. First, I think there's no escaping the conclusion that Johnson and Baez directly conflict with one another. The government claims they don't conflict because this court in Johnson, quote, relied on the fact that South Carolina had construed its tint statute such that registration was an essential element of liability, whereas Baez supposedly construed the Maryland tint statute.
We're getting all tangled up in what the laws of Maryland and South Carolina and Pennsylvania and whatever required. Does this state require registration? Does this state not require registration? But part of the difficulty that I'm having, when I visit a car dealer lot and, looked around the dealer's lot, pretty extensively because between myself and my family, we bought a lot of cars. And I haven't seen many, cars in the dealer's lot with, tinted windows. Either on in this case, it was both the side and the front windows. Why wouldn't that arouse suspicion? Because if you have a car in the dealer's lot with both side and front windows tinted, who's gonna buy it?
So let me say a couple points in response, Your Honor. First of all, the government below raised only one argument in support of reasonable suspicion, and that was the tint statute. They never argued that the car was invalidly registered in Pennsylvania. And in fact, at the motions hearing, if you look at pages 104 to 106 of the joint appendix.
I want you to answer my question. Why would somebody have a car, why would a dealer have a car in the lot with tinted windows on both the front and the side?
Your Honor, I don't know. So with the Pennsylvania plate, though, the question becomes, is there a reason to think that the car is not validly registered in Pennsylvania? And there are a couple of reasons why there's no reasonable suspicion as to that. So first of all, the government has still to this day not cited any Pennsylvania statutes saying that a car with heavy tint can't pass inspection and can't be sold. But even if those statutes exist, Officer Stewart testified he was not familiar with Pennsylvania's traffic code. He doesn't know Pennsylvania law. And under this court's opinion in Williams, which we cite in our reply brief, to make to make a car stop, the officer has to know.
I understand you're trying to argue the particulars of Pennsylvania registration, but the question I'm having is that the combination of the dealer's tag plus the tinted windows would lead a reasonable officer to believe that something was amiss. I mean, is the officer just supposed to shrug and let the car go forward? Because there are all kinds of reasons that a dealer wouldn't be carrying wouldn't be displaying a car. One of the reasons is that it's not going to be, that kind of car is not going to be sold, and the dealer, after all, is in business to sell cars. And the other thing is that it's not going to pass inspection. And so you've got a situation where the car is not going to be a tinted car in a dealer's lot. It's an advertisement that, hey, this, you don't, even if you'd want to buy it, this isn't going to pass inspection, and you're not going to sell it. And so an officer would be amiss. It seems to me if we have a requirement that, oh, you're just supposed to let that go by unnoticed, that's problematic.
Well, Your Honor, he has to have reasonable suspicion that some traffic offense or other offense is being committed. And when a car has
But even if there's a even if the stop is for a traffic expense, for a traffic violation, as a matter of course, an officer's going to be asking probably for a driver's license initially and a registration statement at that point, and perhaps an insurance card that shows that the car is covered. But registration aside, there is something unusual, and not in a good way. If it were just a dealer's tag, that's fine. People have dealer's tags all the time. That doesn't arouse any suspicion. If they were just tinted windows, that's probably okay too, because there are a lot of cars with tinted windows. And so it's either of these things by itself isn't problematic, but the combination of them raises questions that in terms of the traffic laws and the rest, that something is not right. Something could be very wrong, and I want to check this out.
Well, and an officer is allowed to have suspicion, but again, to go to the next step and make a stop, there has to be reasonable suspicion of some crime. And the government has, in this case, where the car has Pennsylvania plates, and Maryland law says that foreign cars can be driven with a valid out-of-state plate, the question then becomes, is the Pennsylvania plate valid? And that depends on Pennsylvania law. And again, Officer Stewart testified that he was not familiar with Pennsylvania law. So even if, in theory, the court could assume that officers, in some cases, know other states' law, in this case, Officer Stewart said he did not know Pennsylvania law, and this court's opinion in Williams, which I cite in the reply brief, says an officer must know that the facts he's seeing represent a violation of the law. He has to know the law. It's not sufficient just to know the facts. The officer must know the law as well. And I would like to go back again to the fact that the government never raised this theory below. Okay, in their pleadings below, they raised
What
only.
about the district court judge made this finding? Detective Stewart's unsuccessful attempt to ascertain the accurate state of registration before he initiated the traffic stop is a critical factual distinction from the Fourth Circuit's Johnson's case, where there was no attempt to verify the place of registration. But in this case, Stewart sought to determine the place of registration without success, and found that was a distinction. Is that, I'm assuming your argument is that that was an invalid conclusion by the district court, or?
Factually, I think it's correct. I just think it's legally irrelevant. The fact that the officer tried to confirm the registration before making the stop doesn't change the fact that he did not know that the car was registered in Maryland. That's legally irrelevant. The officer has to know it, and the fact that he tried to get the information but couldn't doesn't change the fact that there is no reasonable suspicion that the car is registered in
I
Maryland.
understand that the government raises a whole bunch of arguments on appeal that they didn't raise below. Could you clarify for me what it is they actually argued below?
Yes, Your Honor. The one and only argument the government made below is that the car, that Officer Stewart had reasonable suspicion that the car was in violation of the tint statute. And again, this is extremely clear if you look at pages 104 to 106 of the joint appendix. That's the beginning of the motions hearing where the district court comes out and says, basically, I'm going to set the table for what's at issue today. Counsel, if I miss anything, if I leave anything out that you think is important, I ask you to supplement as well. And then the court said, according to the government, Officer Stewart effectuated the warrantless stop because of a suspected window tint violation under Maryland law found at the transportation article of the Maryland Code, section 22-406. And then the judge said on the next page, so I think I've laid out our background to get started, but again, I invite you to correct anything I've said if it's incorrect, of course, or to add to it if you feel it's inappropriate. I'll start with the government. And the prosecutor said, no, that sounds correct, Your Honor. In other words, affirmatively waiving any other basis for the stop besides the window tint statute. We cite cases in our reply brief that say this court cannot affirm on alternative grounds that were not properly raised below. This ground not only was not, the registration grounds not only were not properly raised below, but they were affirmatively waived on the record at the motions hearing. Now, the government, to be clear, did mention the dealer's tag. I'm not saying that the government didn't mention that fact. They did. But the importance of that fact, according to the government, was that it suggested the car was actually registered in Maryland, or that which doesn't make sense to me, but that was the argument they were making. Or that the officer should be able to stop the car to check whether it was registered in Maryland. But the government never cited the registration statute. It never suggested that the car, that the stop was independently legal because of invalid registration. Those arguments just did not come up. And if you read through the transcript of the motions hearing and their pleadings, they cite the tint statute over and over and over again, and they refer to the tint law over and over and over again. There's not a peep about the registration statute. It is entirely new ground, and it's just not a ground on which this court can affirm.
Well, let me go back to good faith before your time runs out here. So let's assume that we have two stops, and the facts are completely identical. And so the officer and the defendant go to court in the morning in Maryland State Court under these facts, and there's no problem with the stop. He goes in the federal court with a different defendant, exactly the same facts, in the afternoon, and you say there is a problem there. So how is the reasonable officer supposed to differentiate that situation so that good faith does not apply?
So a couple answers. First of all, if the officer wants to make the stop, he can do so and take the case to state court. Most cases go to state court. So we're not saying that there's, the officer is totally, his hands are totally tied. He can make the stop if the case goes to state court. But to answer your
Well,
question.
these are two different stops, and I don't know how much control he had over where the prosecuting attorney's gonna bring these particular
Sure,
cases.
the prosecutors can take this, I'm sorry, the prosecutors can take the case to state court. But to answer your question, Your Honor, what the Supreme Court said in another case called Johnson from 1982 is that when Fourth Amendment law is, quote, unsettled, courts should apply the exclusionary rule so that police are encouraged to, quote, err on the side of constitutional behavior. So Baez, at most, renders the Fourth Amendment law in this case unsettled. We have two conflicting opinions. So in that case, Johnson, the Supreme Court's Johnson case says, apply the exclusionary rule so that police err on the side of not violating someone's rights. And that's not my rule, that's the Supreme Court's rule. And that's why all the cases we cite in our briefs say that the good faith exception applies when the law is unequivocal, undisputed, well-established, and not when it's unsettled, unclear, and not well-established. And this is, we cite the Lara case from the Ninth Circuit, which I think is the most directly on-point case that either party cites. In that case, there was a California state intermediate appellate opinion saying that a certain kind of Fourth Amendment cell phone search was legal. There was a Ninth Circuit case directly on point in the opposite direction saying, no, it's illegal. And the Ninth Circuit said you cannot apply the good faith exception in that case because the laws conflict.
All right, thank you, counsel.
Thank you, Your Honor.
Mr. Bornstein?
Yes, good morning, Judge Wilkinson, and may it please the court, David Bornstein on behalf of the United States. The district court denied Mr. Brandon's suppression for 3 separate and independent reasons, each of which is sufficient to affirm. The most straightforward path is that the district court properly held that the Baltimore City police detective who pulled over Mr. Brandon had reasonable suspicion to do so. Reasonable suspicion is simply a minimal level of objective justification for the stop. That is the Supreme Court's decision in Illinois v. Wardlow. And as Judge Agee pointed out, on pages 479 and 480 of the joint appendix, the district court said that the critical factual distinction in this case is that before the police officer pulled over Mr. Brandon, he saw the Pennsylvania dealer's plate. He concluded that that dealer's plate was out of place and inconsistent with the condition of the vehicle. The condition of the vehicle was that all of its windows, front windshield, back windshield, and the sides, were completely tinted, so dark that even though it was a sunny day in mid-May, and I asked you to turn to page 5 of the government's brief.
So what was the reasonable suspicion of what crime at that point?
That the car was not displaying a valid registration plate. That is a requirement under Maryland law. It's Maryland.
Is that what you argued in the district court?
Your Honor, it was part and parcel of what we did, but the
Okay,
most
so that's a
important.
no.
But the most important part is that that was the district court's decision.
Do you, I understand that
And we
part. Do you
cannot-
disagree with opposing counsel's recitation of the record at JA 104 to 106, where the district court laid out what the government's argument was, and the government agreed that's what the argument was?
No, I don't disagree. We
All
were
right.
relying upon the window tint statute. But part of the window tint statute is that you have to look at what the car's registration is. And I think the argument we were making was that the officer had reason to suspect that the Pennsylvania plate wasn't valid. And indeed, that is what the district court
But
seized
what
on.
made the officer have reasonable suspicion to suspect then that the car should be registered in Maryland?
Your Honor, again, what matters
There's
is
a lot of
that.
states, it could be any state.
So, Your Honor, this is an objective test. My friend cites United States against Williams. I would urge the panel to look at it. In Williams, that was a case in which a police officer pulled over a vehicle and he cited the wrong statute. He said, I think that the vehicle was violating this statute. He got it wrong. And the officer couldn't actually cite the correct statute. And this court said, it's 740 F 3rd 308 at 313, that it doesn't matter. that the officer was unable to cite the correct statute. What matters under the objective test is, was the officer able to identify facts that objectively gave rise to reasonable suspicion? And here the district court.
What fact objectively gave rise to reasonable suspicion that there was some Maryland tent law being violated?
So again, Your Honor, what we are looking at is Maryland Transportation Statute 13-402.1 sub A sub 1, which says that out-of-state vehicles must be displaying current registration plates.
And that's, okay, and just to cover the bases, that's one of the arguments that was not made by the government below, correct?
I believe it was an implicit part of what we were arguing, but the most
okay, so
important
no.
thing.
But I just don't understand how that makes it reasonable that that car needed to be registered in Maryland.
Your Honor, the idea is that the officer looked at the car and he said, all right, it's got a dealer's plate.
Looks
And
like
when
looks like it's a Maryland car.
No, and when he was asked, why did you suspect that that plate wasn't valid? He said, it's out of place. He said, dealer's plates have to be on cars that are being held for sale. He said that car was not in a condition to be sold because it couldn't pass an inspection.
In Maryland, to be sold in Maryland.
He actually didn't specify.
Because, well, does he know all the laws of all the other states?
Your Honor, he doesn't have to. That's a point of Williams, and that's a point of the objective test.
You had a, I've taken you off track and you and I aren't gonna agree on this, so what was your next?
Well, actually,
Before
you know,
we leave,
I
excuse me,
Oh, yes,
before
Your
we
Honor.
leave that point, I don't think that the Supreme Court decisions would uphold the point that an officer has to be fully conversant with the different registration laws of different states in order to have reasonable suspicion for a stop here. It's the officer's obligation to ensure that the traffic and registration and driver's licensing, that the whole panoply of laws that govern the rules of the road are complied with.
Yes, Your Honor.
And as I say, regardless of the officer does not need to take a course in this state's registration, in that state's registration. The point is, does an officer have reasonable suspicion that something is amiss when you see side windows tainted, and not just marginally tainted, but tainted so that no eyes of any kind can get through. And they're not only, the side windows are completely blackened in, the front windshield is completely blackened in, and in addition, you've got a Pennsylvania dealer's tag with a car that isn't going to pass, that no dealer would casually carry that car on the lot because it isn't going to be sold. And it isn't going to be past inspection.
Absolutely,
And you're
Your Honor.
probably going to turn off people having something like that and say, I'd look at it and say, what in the world is this dealer doing carrying that kind of inventory? And I would say, normally when I go to look for a used car, I want to have some kind of confidence that the dealer is up and up and is carrying an inventory that is inspection worthy and sale and whatever. And a car like that would say, what in the hell is this dealer doing? And it would turn people off. And then the officer has a general, the officer does not have to know the particulars of this state's registration. And that, when you see a combination of totally blackened windows that nobody can see through and no sunlight can get in and no eye can pierce, and then you combine that with the dealer's tag, Of course you'd have reasonable suspicion that something was not in order in the, whether it be the registration statement or whether it be the driver's license or what have you. You would certainly have a reasonable suspicion, hey, something is weird about this. I have not seen that kind of combination. I've been on the road a long time, and I have never seen a car that has a dealer's tag and tinted windows. It's just, you just are gonna have a reasonable suspicion that the basic credentials of driving
We-
are not in order.
We fully agree, Your Honor. And I think you're hitting on how low of a bar reasonable suspicion is.
And is
It's
that what
simply-
you argued below?
But, Your Honor, it doesn't matter. Yes, it is. It is
Waiver
an
doesn't
implicit-
waiver doesn't matter? Does it matter when the defense doesn't argue something
Your
below?
Honor, as the appellee, this court, of course, can
Usually it
affirm.
does.
But, Your Honor, this court can affirm on any ground that appears
I
in the
understand.
record, and this is actually the basis on which the judge ruled. That's page 480 of the joint appendix, but don't take my word for it. Actually, I'd like to turn your attention to joint appendix page 645.
480 of the joint appendix.
Well, actually, 645 of the
Okay,
joint
and
appendix. My friend decided to include the suppression transcript of a later case, United States against Leonard. And in that later case, my friend's office, the federal public defender, distinguishes Judge Hollander's decision in Brandon from what was happening in Leonard.
So
And let me
what
explain to you.
What line are we looking
Wait.
at?
Is
so
this
it-
645 you're talking about?
645. It starts at line 3. This is a federal public defender. And I quote, Brandon in particular, skipping down, did have a lot of those additional X factors as well. It had a dealer's tag from Pennsylvania. The dealer's tag seemed out of place. It seemed out of place because they knew that if you had a car like that as a car dealer, you wouldn't be able to sell it if it was so darkly tinted, right? So there's a combination of factors that were adding up to suspicion, but they also sought to verify the place of registration. The district judge then responds, right, I mean, there was suspicion about the validity of the tag. The federal public defender responds, right. That is the FPD's own interpretation of Judge Hollander's decision. So it is simply disingenuous for them to now stand up and say that the
This is-
suspicion
But
about
then,
the validity of the tag,
Excuse me, Judge Thacker,
Mm-hmm.
you
Yes.
go ahead.
sorry.
No, oh, no, you go ahead.
I was gonna say, to my mind, this is not a simple question of which state law required what registration. It is a question of the totality of circumstances here indicated that something was weird and something was amiss with respect to compliance with the most basic rules of the road. And I can't believe that we would be saying that an officer, police officer, is gonna be seeing a car with a dealer's tag and blackened windows, and knowing that those two are incompatible with one another, and he just has to shrug and say, oh, no problem. And we're talking about allowing an officer to just, which they do all the time, to stop and ask for the registration and ask for a driver's license and often to ask for an insurance certification.
Yes,
And that's basic to policing traffic and the way that drivers are supposed to operate.
We agree.
I've got another question about another aspect of this case, but Judge Thacker had some questions she wanted to
Yes,
ask.
sir.
Thank you. Yeah, just real quick, I did want to hear what you wanted to say about JA 480, because I think you were saying that's the basis
Sure.
upon which the district court ruled.
So, and I'll just read from it. I think
Yeah,
it's
I'm
plain
looking
on
at
its face, from the top. As I see it, Detective Stewart's unsuccessful attempt to ascertain the accurate state of registration before he initiated the traffic stop is a critical factual distinction from the Fourth Circuit's Johnson case. As discussed at length, the purpose of a Terry stop is to investigate possible criminal activity or dispel suspicion. The suspicion that the officer had was that this plate was out of place, and I want to note, Judge Wilkinson is absolutely correct. My friend cites nothing saying that you have to peer inside of the officer's mind and see if he knows the law, have him pass a bar examination. The case law is very clear. The officer must identify facts, and then you ask whether a reasonable, well-trained officer knowing those facts would have reasonable suspicion, and the answer is yes. I mean, as a legal matter, there's no...
Reasonable suspicion of what?
that the car was not displaying valid registration plates as required by Maryland Code of Transportation, Section
Okay, and that's
13-402.1, Sub A, Sub 1.
Okay,
And it can't possibly be the case that simply because the district judge did not cite that statute after saying that the officer had reasonable suspicion to dispel suspicion about the tag, that suddenly it has been forfeited, Your Honor. And I want to
Point
note
is,
that as a
it's
legal
not
matter,
It's not a reasonable suspicion necessarily that's tied to registration. It is a reasonable suspicion that
We-
this combination of factors
we agree, Your Honor.
led to a reasonable suspicion that the driver's credentials were not in order.
And Judge Wilkinson, if I could add, we absolutely agree. But to boot, the officer was fully correct in everything he believed. He said that he believed that for that dealer's tag to be valid, the car had to be held out for sale. And indeed, under Pennsylvania law, this is Title 75, Section 1336 Sub A, dealer plates may only, quote, be on vehicles being held for sale. And then my friend said, well, you know, was the officer also right that that car had to pass an inspection and it couldn't have dark window tints? Yes, the officer was correct. This is Pennsylvania Department of Transportation Vehicle Equipment and Inspection Regulation 175.8, which says that for a vehicle to
No,
be
but the
sold.
point is that we can't transform officers, there's a limit to which we can transform police officers into lawyers.
Agreed.
There just is, and the Supreme Court has made that point over and over. They sometimes approach things, we've approached things from a very legalistic point of view, and we're gonna ask whether this registration or that is in order. But you know, the point that the Supreme Court is making in Illinois v. Gates and in a number of cities
Common
is
sense,
that
Your Honor.
officers are they're not, they're supposed to know basic elements of law, but they're not trained in the refinements of law. They are trained definitely in basic legal requirements such as reasonable suspicion, and they just can't go around stopping cars willy-nilly. They can't do that. But there's a difference between being aware of basic requirements of law and being required to master the refinements of registration law, because they do have, what they bring to this whole situation is a certain practicality of judgment.
We agree, Your Honor.
And that's what this officer exercised. It was a practical instinct that there was something just weird and wrong, and that this driver's credentials are not in order.
We fully agree, and I really do believe, I mean, looking at the photo on page 5 of the government's brief, you know, it's a sunny day. The sun is beaming down on the car. There's an officer to the left sweating, and you see a completely black windshield. You can't even see in with the sun directly shining on it. I think any of us who've actually walked by one of these cars where everything is tinted over and you can't even see it, it is very strange and intimidating. And I agree, a common sense judgment by an officer would look at that dealer's plate and say, I'm sorry, that's just not right. And that actually turned out to be not right. It was a completely unregistered vehicle. The
Let me
defendant
ask you
said that he got the
something.
plate from someone
Let me
else.
ask you
Yes, Your Honor.
on another point here. The conduct that was displayed after the stop
Yes,
was very disquieting.
yes,
And there was a tussle there, and then the driver puts his foot on the accelerator.
yes, Your
And
Honor.
as I understand it, the officer was dragged across the street.
That is correct.
I mean, was the officer on his back?
No, so what happened is, and I'll turn to the attenuation point here, Your Honor. But if you don't mind, just for one thing, because my friend specifically asked me to cite the regulation, I just want to point out to Your Honor that under the Pennsylvania Department of Transportation's regulations for vehicle equipment inspection, 175.8, it has to pass the inspection, and then 175.67 sub D sub 4, no car may have a tint which, quote, does not permit a person to see or view inside of the vehicle. So the officer, despite saying he was not familiar with the laws, traffic laws of other states, he did say he knew about dealer's tags, and he was absolutely correct here. Now to attenuation, Your Honor. We believe that another grounds for affirmance is that the district court properly held that the seizure of the firearm was attenuated from the initial stop, assuming that there wasn't reasonable suspicion. And to clarify, my friend says that we concede that there wasn't reasonable suspicion. That was taken from the good faith and attenuation arguments where we're proceeding under the assumption that there wasn't.
You're going to answer the question about,
Yes.
I want to know what test is there in terms of dissipation of the tent? I mean, for
Absolutely,
example,
Your Honor.
suppose the driver decided to pull a gun and actually fire and shoot
Yes, Your Honor.
the officer. The exclusionary rules would apply to that. Let's say the driver was sitting there, and then in the middle of the inspection, or in the middle of producing a credential, he essentially produces a gun and shoots the officer.
So if,
Does a murder after a traffic stop dissipate the taint?
I believe it wouldn't. The governing decision here is actually Judge Agee's decision in United States against Gaines. And if I can just do a little bit of table setting, there's a precedent to this court, United States against Sprinkle, that says that if a defendant is illegally stopped, but he commits a new crime during that stop, then any gun that is taken off of him pursuant to a search incident to lawful arrest for that new crime is admissible. Gaines created an exception there. And the Gaines exception is that if the police discover the gun before the new crime, then there is no attenuation because there is no intervening event. So the question here is, when was the gun discovered? The district court, as a finding of fact, said that the gun was only discovered after the intervening crime, where the defendant tried to drive off, crashed into an occupied car, crashed into a telephone pole, and injured the officer. After that happened, other police officers arrived on scene. I actually asked,
So we would have to find that finding of the district court was clearly erroneous. in
To
order
overturn it.
Overturn.
I'll say, my friend doesn't actually seriously try to argue it's clearly erroneous, and the facts support what the district court found. The record, first the district court looked at what the officer testified to in the suppression hearing. On page, Joint Appendix page 142, the officer said that he saw, quote, a bulge of the shape and size of what I believed to be a handgun when the defendant got out of the
But
car.
the question is, do we have here the kind of intervening criminal offense
Yes.
that would dissipate the taint?
And I'd say yes, because it goes to what discovery means, and that was the key issue in Gaines. I looked it up in the dictionary. Discovery means, this is Merriam-Webster, to obtain sight or knowledge for the first time. When the officer saw the bulge on the defendant, he then had reasonable suspicion that there was a gun. That is not discovery or knowledge, but reasonable suspicion for a pat-down. That's what he proceeded to do. He started to the left, he then went to the right. Watch the body camera footage, because that's the second thing the district court looked at. The district court then noted that when he felt the bulge, 3 times he asked the defendant, "What is this? What is this? What is this?" Showing that the officer had not yet discovered that it was a firearm. For this court to find that it was clearly erroneous, that by seeing a bulge, the firearm was discovered, the officer would have jumped over reasonable suspicion, jumped over probable cause, to knowledge that the defendant was unlawfully possessing a firearm, and that's just not right.
Okay, thank you, counsel.
Can I ask him one more question,
sure.
if I could? If you could give us an abbreviated response to the good faith argument of opposing counsel.
Sure, Your Honor. I really think when it comes to good faith, it is determined by what the good faith analysis is. The district court cited it. It's set forth in Herring against the United States. The inquiry is whether the question is the objectively ascertainable question whether a reasonably well-trained officer would have known that the search or seizure was illegal in light of all the circumstances. There has been nothing brought forward by my friend showing that under the circumstances here, where the police officer reasonably suspected that the Pennsylvania dealer plates were not properly on the car, that it was illegal to pull over that car. My friend relies upon the Frank Johnson decision from this court, but as footnote 2 of that decision makes very clear, there was nothing in the record showing that the officer had any reason to suspect the validity of the out-of-state plate. Here the officer did. In United States against Stevens, this court made it very clear that my friend relies upon the Supreme Court's decision in Davis. This court in Stevens said Davis is actually, sets forth only one instance in which the good faith principle applies, but there are many other, and we need to go back to that fundamental test, which I just said. And again, as this court said in Stevens, because exclusion is a last resort and not a first impulse, it's probably more proper, this court said, to talk about in terms that the exclusionary rule is more the exception. And since there's nothing that would have shown this officer that what he was doing was illegal, especially because Baez sets forth the principle that in general, if an officer suspects that he's pulling over a car with an out-of-state plate and he is unable to determine the state of registration, of course he's able to do so.
All right,
That's
thank
good.
you. Let
Right.
me ask,
Thank you, Your Honor.
hold on one second.
Yes, Your Honor.
Judge Thacker, he has some questions.
That's
You
good.
okay?
Mhm.
You fine? All right.
Thank you. We ask that you affirm.
Okay, thank you. And, Mr. Macbeth, you have some rebuttal time, sir.
Thank you, Your Honor. I'd like to start by going back to your point, Judge Agee, about two different stops leading to different results in federal and state court, and just say that that happens all the time. That's a feature of our federalist system, that judges in state court will apply state law, and sometimes that'll be different from what federal law is, and that is not necessarily a problem. That's something that we see every day. And so the question is, when this officer has two cases directly conflicting with each other on the legality of the stop, what is he supposed to do? And again, the Supreme Court's Johnson opinion says, err on the side of constitutional behavior. It's like what the Supreme Court said in Leon, which we cite in our brief. They indicated in that case that if one judge rejects a warrant application and then a second judge approves it, it would be unreasonable to rely on that application given that it was previously rejected by the first judge. And that is analogous to what we have here. This court rejected the legality of the stop in Johnson. Baez approved it, but under those circumstances, it's not objectively reasonable to proceed. Opposing counsel said that police officers are not required to know the law, but the Williams case actually says they are. And if you go back to Williams, it's quoting from.
And then they also argue good faith, wherein they must need to know the law.
Correct, exactly, Your Honor. And in Williams, this court was quoting from the Sixth Circuit's opinion in Hughes, where the court said, in order for a stop based on a moving or parking violation to be permissible under the Fourth Amendment, it is not sufficient for a police officer to know the facts that give rise to probable cause or reasonable suspicion. He must also know at the time of the stop that those facts give rise to probable cause. In other words, he must know the law. And Officer Stewart clearly testified he did not know Pennsylvania law, so he doesn't know whether the registration is valid in Pennsylvania. He has no basis to know that, and under Williams, he has to know that. That is the law. Opposing counsel also said that this court can affirm on any ground supported by the record. That is an incomplete statement of the law. The court can affirm on any ground supported by the record that was properly raised below, and opposing counsel essentially conceded that they did not raise any basis for the stop besides the window tint statute. So under those circumstances.
But then he also directed our attention to JA 480 and indicated that the issue with the registration was part and parcel of the district court's decision, and so it's properly before us.
So what I read the district court to be saying is that the stop was legal under Baez, and what Baez said is that an officer can stop a car to check the registration to see whether it is registered in Maryland and therefore subject to this tint statute. It's all part of the Maryland tint statute argument. It's not about a separate invalid registration argument, which was never raised below.
Why don't you take your remaining time and tell us about the intervening criminal act?
Sure, Your Honor. So first of all, the government for the first time today has said that discovery is a finding of fact subject to clear error. That's not how this court reviewed it in Gaines. To be honest, Gaines didn't say exactly what the standard of review is, but I think it is either a legal question or at best a mixed question of law and fact, because the brute facts of what happened are subject to clear error review, but whether that qualifies as discovery, I think, is a legal question. In any event, the plea agreement in this case, which the government authored, and in which the government agreed and stipulated that it could prove the facts in there beyond a reasonable doubt, says that when Officer Stewart put his hands on the gun, it was immediately apparent that the object was a gun. If that's not discovery, I don't know what discovery is. If it is immediately apparent to you that something is a gun, then the gun has been discovered. The government emphasizes that Officer Stewart said, "What is this?" 3 times, but again, we cite to Beauchamp, which the Gaines opinion said was consistent with Gaines, and in that case, the officer asked the suspect as well, "What is this in your pants?" And notwithstanding the fact that the officer asked a question, the Sixth Circuit said that the object had been discovered previously. Also in Beauchamp, the officer looked at the plastic bag in the defendant's pants and, quote, assumed that it was drugs, but didn't know, he wasn't sure, he just thought it was. And nevertheless, the Sixth Circuit said that that object had been discovered before the intervening act. So since Beauchamp is consistent with Gaines, that would indicate that the item was discovered here before the intervening act. And finally, Gaines also said its opinion was consistent with the First Circuit's case, Camacho. In that case, the police officer tapped the gun with his hand once. The defendant immediately took off. That was it. Under those circumstances, the court said the gun had been discovered. The officer didn't manipulate the gun. He didn't hold on to it. He didn't do anything other than just tap it once. And on those facts, the First Circuit said that's discovery. Here we have the officer holding the gun, and it is immediately apparent to him that it's a
All
firearm.
right, thank you, counsel.
Thank you, Your
Hold
Honor.
on a minute. Steve, we have no further questions.
Thank you.
All right, we will come down and greet counsel and then proceed directly into our last case. I want to thank Mr. Macbeth. I see that you're a court-appointed public defender, and I really want to thank you. You've done a fine job representing your client. I'm wanting to express the appreciation of the court.
Thank you, Your Honor.
Please be seated. All right, we're here to hear Cooper versus City of Wheeling, and Mr. Stewart, pleased to hear from you, sir.
Good morning, Your Honors. May it please the court, my name is P. Zachary Stewart, and I represent the appellant Ashley Anna Cooper. This case arises out of the West Virginia Northern District. It is an appeal of Judge Bailey's order granting appellee's motion to dismiss. The reason we're here is a relatively narrow issue, which is whether the statute of limitations for a 1983 claim arising in the state of West Virginia is 1 year or 2 years. The City of Wheeling, in addition to that matter, the City of Wheeling, based on its response brief, hopes that this court will consider the failure to state a claim argument from its original motion to dismiss. But once again, that's not why we are here. It would have greatly assisted this court if it were taking up that argument and had the district court opined on that particular matter. case, the facts in this case date back to December 2021, when there was an incident at Northwood Health Systems in Wheeling, West Virginia. A young lady who was in one of the counseling sessions there battered the moderator or teacher at the session. The police.
I think we're familiar with the facts of this case, and it seems to be a fairly simple decision here in terms of the statute of limitations. Supreme Court's told us we're to use the general residual statute, which would appear to be subsection B of 55-2-12. And we have a case, Travel Peace, I think that's the name of it, that says that's what it is. It's fairly recent. And that resolve at least as to the individuals. Doesn't that resolve the argument?
Yes, it would, and even if the court wanted to take a step further on that, there was a case decided out of the state of South Carolina earlier this year, when ER versus Beaufort County School District.
The state of South Carolina?
Yeah,
Is
it
that
was
what
out
you're
of-
saying?
yes, it was out of
But
the
you have Fourth Circuit and Supreme Court a precedent in your
That's correct.
favor, so
However, yes,
we don't, I mean, that's not precedential when we have our own precedent,
It
and
actu-
it's in your favor, so
it
maybe
is.
you should just stick with Fourth Circuit and Supreme Court, but you argue it however you want.
Sure, actually, it brought here to this particular circuit, and in that matter, it applied Wilson and Owens, and deemed that the 3-year residual statute of limitations
And so you
should apply. So it's the
you are arguing the Fourth Circuit precedent. You're
Yes,
not, okay, I understood you to be arguing like a South Carolina state court decision.
I apologize. No, it
Okay.
is from this court in which, once again, applying the residual personal injury statute,
And
which
it's all in your favor.
in that sense, yes, it is.
What about the city of Wheeling as a separate defendant? What is pled in the complaint that shows their liability?
I will concede that that part of the complaint is not well pled in the sense that of connecting Monell liability to the city of Wheeling. However, with
Well,
with permission and leave to amend.
Why wouldn't we just affirm on that basis? You could always replead as far as the city's concerned, couldn't you?
I could, with permission of the court, could replead and connect the liability and show that there's employer liability for the officer's errors in this matter.
All right.
May I reserve the rest of my time for follow-up questions? I believe that this city of Wheeling is going to have arguments to make on this matter.
You're in control of your argument, sir.
Well, then I'll just highlight one more thing for the court, and that is, even on this particular matter, which I believe is clear that it should be West Virginia's 2-year statute of limitations as previously held by this court in the travel piece matter, this confusion that came out of the district courts is obvious from the face of the order granting dismissal. It cites both 1-year statute of limitations, applying a 1-year statute of limitations to certain cases that are 1983 claims, and then also stating that it applied a 2-year statute of limitations in West Virginia to certain 1983 claims. It's time that this court speaks and states that it is the 2-year statute of limitation on 1983 claims that applies for the claims arising in the state of West Virginia. Even the counsel for even the city of Wheeling has gone back and forth on this argument, as highlighted in the order granting dismissal, which shows that the city of Wheeling first argued at the district court level that yes, it's the 2-year statute of limitations. However, the city of Wheeling also argued in a separate case, as shown in a footnote within the order granting dismissal, that no, it should be the 1-year statute of limitations. This back and forth needs to end. It just needs to be settled by this court what amount of time should apply on this particular matter. As far as what we've seen from the Supreme Court, this court, its 2-year statute of limitations, residual personal injury statute should apply. I yield my time, and I'll turn it over to the city of Wheeling.
Mr. Buck?
May it please the court, my name is Thomas Buck. I represent the defendants in this case. And the case, the court's correct, this case is a very narrow issue. But the narrow issue is focused on really what is the residual statute. So the residual statute in West Virginia is the entirety of 55-212. So in Owens does say if there's multiple enumerated statutes of limitations for intentional torts, then we go to the residual statute. We don't have the if in this case. Footnote 12 of Owens says only when there's multiple enumerated statute of limitations do we go to the residual. In this case, we don't have multiple enumerated statutes for intentional torts. What we have is West Virginia always goes to the residual statute in this case. And the residual statute is not, as the appellant argues, just merely subparagraph B of 55-212. 55-212 is the entire residual statute. Its title is Personal Actions Otherwise Not Provided For.
Yeah, but why isn't the 1983 claim here clearly within B? It's within 2 years for damages for personal injuries.
Well, that's because under West Virginia law, this claim does not survive the death of a party. So it goes to Section C of the residual statute. So B is if it survives the death of a statute or survives the death of the party, then we go to B. It's 2 years. Under West Virginia law, the residual statute for actions that don't survive the death of a party is 1 year. That's the residual statute, C. And that comes from a long line of cases well cited.
And that's the malicious prosecution claim you're talking about?
Correct. It's the only claim in the case.
And you're saying because of what you've just argued, it's time barred?
Correct.
Then why in a pleading that you filed in district court did you say defendants agree with plaintiff that her malicious prosecution claim is not time barred?
Because I took a very superficial look at it and I was wrong. And I got schooled by Judge Bailey on the issue, and I went back and looked at it more intelligently and more in depth.
And what would you do with, are you just saying that we're reading the statute wrong? That, I mean, you would apply our
See,
Fourth Circuit and Supreme Court precedent, but you just say we're reading the statute incorrectly?
oh, this court's never read subsection C. You've never done it incorrectly. We're not changing anything.
Explain to me about why we need to look at it the way you're saying
Okay, so
now.
the general rule is survivability of an action is not provided for under Section 1983. So the cases, Robertson versus Wegman and so on, say we look to the state's survivability rules. That's well established. So the survivability of the cause of action is controlled by the forum state. And under Wilt versus State Auto, it clearly explains the residual statute in West Virginia. If the statute survives the death of a party, the residual statute's 2 years. If the cause of action does not survive the death of a party, it's 1 year. That's the
So
residual
what-
statute.
is
And
there
all
a
we
what-
do here is apply
Okay, hold up.
the
So is there a
statute.
West Virginia Supreme Court case that says with the malicious prosecution claim that expires with the death of the party?
Correct.
All right, tell us what it is.
Wilt versus State Auto, 506 Southeast 2nd, 608. And the whole
Is
host of
that,
cases
is that
they
in your
cite.
brief?
It is not. It's a 1998 case. So all we have to do is apply the residual statute. And that's all the Judge Bailey did, was,
Wait, Wilt versus State Auto,
yes,
it is in your brief.
it is,
Yeah,
my mistake.
if you're yeah, it's at,
Page 6 and
pages 6
se-
and 7. Uh-huh.
So all we have to do is apply the statute of limitation, the proper application, the statute of limitations. And when this court looked in the other case that plaintiff cited, we weren't dealing with a cause of action that didn't survive. So what you looked at and said, okay, well, 2-year statute of limitations, it was subparagraph B. Here, this case is subparagraph C. And subparagraph C of the residual statute is 1 year. We're done in 1 year. So it expired, and Judge Bailey applied it right. So that's really how this case comes down. If we really want to look at, you can look at West Virginia Code Section 55-7-8A. It specifically enumerates the causes of actions. That is in my brief. It enumerates
suppose
actions
it's a-
that survive.
As opposed as a practical matter, you've got all these West Virginia district court decisions saying that the 1-year statute of limitations is the correct one.
Yes.
Right. So I suppose there's some advantage in not just churning that up and destabilizing what has been a fairly stable rule of law within the district courts. Is that correct?
That's very true. And it's important because,
But aren't there a whole other set of cases in West Virginia that say the opposite, that apply subsection B to malicious prosecution claims? And that seems to be all over the board here.
no, it's pretty consistent. Where B gets applied is usually assault and battery claims, things like that, improper taking of property, improper
Guess
search and
I'm
seizure.
looking at district court cases in West Virginia that have applied the subsection B to malicious prosecution claims, and then there are some that apply the 1-year statute to statute limitation, to malicious prosecution claims. It's not consistent. It's not, well, I mean, I'll give you a whole list of Southern District and Northern District of West Virginia cases that apply subsection B to malicious prosecution claims.
Yeah, and I may not be the only person that looked at it superficially and accidentally used subsection B.
So you think Judge Goodwin did, Judge Keeley did, Judge Berger did, Judge Chambers did, they all got it wrong.
Well, I think some of those cases, and I'm not gonna I can't go through all of them. Some of those cases also had claims that survived 2 years.
Yeah,
So they
I get-
weren't solely malicious prosecutions. What's unique about this case is plaintiff has stipulated, and everybody agreed, the sole claim is malicious prosecution. We don't have an assault and battery. We don't have a taking of personal property. We don't have those other claims that the 2-year statute of limitations applies to. This is very narrow. It's solely malicious prosecution.
So,
Yeah,
you
I-
say this,
No, I was going to say, I suppose that one reason the 1-year statute of limitations has been applied where the sole issue is one of malicious prosecution is that the statute begins to run on a malicious prosecution claim when the decision is decided in the defendant's favor, right?
Correct.
Okay, and so the question of notice, of when you have notice of a particular claim, that doesn't arise in the question whether the sole issue is one of malicious prosecution, because the individual is going to be very much aware of when the decision was just resolved in his favor. And so he will have notice that would be fairly clear. So there's no danger really of the statute of limitations beginning to run when a defendant is lacking basic kind of notice, and that doesn't have to be litigated. In these malicious prosecution claims, the defendant knows darn well when something has been resolved in his favor. So he's on notice very clearly for a fact of which he above all should be aware, that the statute's beginning to run because he won in the criminal case for whatever reason.
That's correct.
So
100%.
that's the practical reason, I think, which may motivate some of, Judge Thacker's right that you get, decisions that are going different ways, but some of them involve multiple claims.
That's right.
And this is one of those that involves purely a malicious prosecution claim. And in this kind of case, the whole question of notice, which is critical to having a statute of limitations run, there can be no doubt
It's crystal clear.
about it, and I think that's the practical reason that's motivating some of these decisions.
Right.
And the decision to take subsection C as, residual.
Yeah.
And so the other question that, comes up is, it's really important, I think, for this kind of claim, a malicious prosecution claim, to be resolved promptly. Because you've got all sorts of collateral attacks that are gonna be brought this way and that. And an element of those collateral attacks is likely to, whether it's malicious prosecution or not, is likely to be critical in any kind of collateral attack that is being brought on the criminal judgment. Although in this case, the malicious prosecution claim would not go forward unless there was an acquittal. But there are other situations where there might be a conviction and still there would be a claim of a malicious prosecution. I don't know, but I think there would be some value in having these sorts of claims resolved sooner rather than later.
I believe so. And if we look at the timepiece case, my colleague wants to say timepiece stands in front of this analysis. It really doesn't. Timepiece applied subsection B of the residual statute because timepiece dealt with a case that did not or could survive the death of a party.
So it was not a malicious prosecution.
It was not a malicious prosecution. It was a property matter. It was a illegal search and seizure of property, which expressly is provided for under 55-7-8A,
But
survives the death of the party.
You say this Wilkes versus State Auto specifically holds that malicious prosecution in West Virginia does not survive, that cause of action does not survive the death of the claimant.
Correct.
All right. 'Cause
Correct.
when you cite, when wilt appears in the catalog of cases, it's not separately argued in your brief. It's just included in several quotes from other cases, and unless I've missed something, you're making an argument now, which may very well be correct, as to lack of survivability that I don't see that was specifically argued in your brief.
It was, because what I said in my brief is we don't look to be in the residual statute.
Well, I know you
We
did
look
that,
to
but the
see.
specificity of why, I don't see in the brief.
That is why C comes in. It's not survivable, and the
So you
specific.
agree that wasn't in your brief, that particular argument?
Section C, which deals with.
You did cite section C, but
Right.
the argument you're making about it now isn't articulated in your brief in the way you're doing now.
Far more detail now, yes. The legal authorities are there, I'm making it in more detail now, yes. No question. And the Supreme Court has never said, it's never said in Owens, it's never said in any other case, that we carve up the residual statute. We ignore the subsections of the residual statute, that we just pick the longest statute of limitations in a residual statute. That's not what it says. The residual statute in West Virginia provides both a 2-year and a 1-year statute of limitations. That's the residual statute. The federal court can only apply that residual statute, and they can't just skip C and pretend it's not there. That's part of the residual statute. It provides for a 1-year statute of limitations.
On the other side of the argument, a 1-year statute of limitations is a little bit unusual. Would there be an advantage in terms of uniformity of just having a flat rule across most of these things?
Well,
Hold on, that the default rule is 2 years. That's a personal injury statute of limitations, generally under 1983. But, you always say, well, what's the default rule? And would the default rule be 2 years? And would there be some advantage in terms of uniformity and resolving confusion and the rest by just saying, okay, it's 2 years?
Well, I think Owens had the opportunity to do that, and the court chose not to. And in footnote 13, it specifically says it does not address the issue or say that 1 year is
So you're
unfair.
saying that Owens requires that we look into state law
Yes.
and that there's no a priori definition of what is residual, that the question, the Supreme Court in Owens did not set forth a rule saying that residual statutes are invariably 2 years.
No, not at all.
They say what you've got to do is look carefully into the state law involved. And and your argument is that when you look into the state law, that the residual part of that is subsection C, and that at least there are a number of district courts that, I think Judge Thacker is absolutely right that there is confusion here and they're going every which way. And I think you also make a good point that those cases all involve multiple claims and that they may have involved different survivorship questions. And so, and I'm sure there are practical advantages to having malicious prosecution claims resolved as close to as possible to the prosecution itself, because that way the parties, it's freshest in the parties' minds. The legal proceeding is freshest in the parties' minds. And it's very much in the public interest to have a malicious prosecution claim resolved sooner rather than later and as close to the prosecution as possible. And that's why they've gone with 1 year, plus the fact that there's no question of notice, because you know
Right.
when a decision has been resolved in your favor. So all I'm saying is I don't see Owens as laying down any kind of flat 2-year rule.
Yeah, and there are other cases that support that. So if we take a look at Kentucky, Kentucky has a 1-year statute of limitations that's been applied to 1983 claims, and the Sixth Circuit upheld that. Tennessee's is 1 year, Puerto Rico's is 1 year, Louisiana's is 1 year, and the Fifth Circuit has upheld that. California's is 1 year, the Ninth Circuit has upheld that. And while the legislature didn't put a statute of limitations in 1984 actions, what they did do is they put a statute of limitations in 1986. 1986, failure to prevent civil rights violation statute.
Well,
The legislature put a 1 year, Our-
West Virginia legislature can change this at any point in time
If they wanted to.
if it wants to, but you're right about the fact that there are a lot of one-year statutes of limitations under state law, and courts have upheld them.
Yeah, in section 1986, USC, one-year statute of limitations. So even our federal legislature has recognized 1 year's okay for that
So
type of
the
civil.
And this
bottom
whole,
line-
oh, go ahead.
The bottom line of your argument is that from Owens, the default rule in West Virginia would be 2 years with an exception where the particular claim does not survive the death of the claimant.
No, it's not. The default rule is 2 years if it survives, 1 year if it doesn't survive. That's the default rule. The default is 1 year in this type of case. That's exactly how that statute's played out. And Owens does not give the federal courts the authority to rewrite the West Virginia statute or skip over subsection C and use B. The default statute is, for this type of case, 1 year. That's proper application of the default statute.
Just if, assuming arguendo that we were to disagree, and I'm not saying we would, I don't know, I have no idea. But assuming that we say, well, it's 2 years and the claim is timely. Would you prefer that we get into the merits, or should we just return this to the district court and let the district court have the first shot at it, since the district court's dismissal was on grounds of timeliness?
I think proper procedure is to, if you would apply a 2 year instead of the 1 year under C, it would be to return it to the court to decide.
Would be to return the case to the district court
Yes,
and let the district court decide it?
yes, I believe that is the
So
best practice.
really
I think
what-
this court would have the authority to do it the other way, but I think
One way or
traditional.
another, really what we have here before us is the question of the statute of limitations.
Yes,
And, yes, that's what was before us, and the problem, at least for me now, is that you're arguing a whole other argument that wasn't really fleshed out in your brief, so I don't know if maybe supplemental briefing is in order, because I find it unfair to not only opposing counsel, especially opposing counsel, but also to the court, that we're not, that this argument, I just don't see it in your briefs.
well, I mean, if the court wants additional briefing, I will gladly do that. I did argue in the brief that it's subsections, that the whole residual statute.
You said subsection
and
C, but
subsection
this
C
whole
controls.
thing that you argued here, that fleshed that argument out in a much better, more clear way, is not in your brief, and I heard you concede that earlier, and I don't think it's fair to opposing counsel, so I just want to note
I
for
would have no
the
objection.
record.
If I want to be completely fair, if you want supplemental briefing, I would.
Now, this
Very
is
much
a
agree
very
with that.
important, it's a very important case, and we probably ought to have the benefit of full presentation on it, where opposing counsel, as Judge Thacker emphasizes, has a chance to respond. Your argument seems to get better and better as it goes along with each iteration.
Yeah, I'm finally
You were
getting to
a
Judge
little-
Bailey's
you know,
level.
you were a little-
First, you said
You
no,
were a
and
little slow out of the starting gate, but then you begun to pick up speed, and so I think that it makes some difference to take heed of Judge Thacker's suggestion and proceed in a way that's fairness to both sides and gives both of you a chance to reflect on what the West Virginia law really is, and how survivorship plays into this, and how the question of multiple claims plays into that, because, you know, we like to get these things right, and it might be good to have some some, I call them supplemental briefs, but you can just as easily term it supplemental reflections. That might be a thoughtful way to go, because I'm not sure, I can see arguments on both sides, frankly, and I'm not, I mean, I understand, I think that, your opposing counsel is, from my mind, trying to read Owens too broadly, more than I think the case will bear. But on the other hand, you've got this West Virginia statute, and if I may put it gently, it doesn't seem to me to be a model of clarity in terms of whether subsection C is residual or whether it's not. And so maybe it's good to take another look at it. I mean, for you all to do something with it. At any rate, let me ask my colleagues if they have some further questions on this. Steve?
No.
Stephanie? Okay,
All right.
let's hear from you.
Thank you very much for listening to me.
Mr. Buck?
Let me ask you first, are you familiar at all with this Wilkes versus State Auto case?
Only to the extent that it is one of the cases that has held that a one-year statute of limitations is applied to the West Virginia state law, West Virginia state malicious prosecution torts, not something that is applied to a federal 1983 variety malicious prosecution.
Well, do you know, I mean, this is probably unfair to you for all the reasons that Judge Thacker and Judge Wilkinson have pointed out, but, I mean, does malicious prosecution, a claim for malicious prosecution in West Virginia, survive the death of the claimant?
No, it does not. However, on the 1980, there is no, I'm going to say this as clearly as I can, as I've written in my notes. There's no indication that a federal 1983 claim, which is what Ms. Cooper has brought in this matter, does not survive the death of a party. So say it the opposite way. For a federal 1983 claim, it does survive the death of a party. And so what the counsel for the city of Wheeling is asking this court to do is consider a state law tort. We are not here because
And it's not applicable here,
it's
in
not
your view?
applicable. It can't be. We're here because of a federal 1983 action. And if we're gonna get into if we're gonna get deeper into statute of limitations, setting an amount of time, a hard number, rather than, like Owen says, to go back to the residual personal injury tort of the state, that was something that was discussed by the Supreme Court in both Wilson versus Garcia and Owens versus Okur. And they declined to put a hard number on it and said instead that was reserved for Congress. Congress is the one that needs to put a number on what the statute of limitations is for a 1983 claim. And without them having put an exact number on it, they had to opine the way they did, and the way they did was go back to the state's residual personal injury tort.
So one of the purposes of Owens and some of the other cases along that line, as I understand it, was that they wanted to get away from the practice of having federal courts look for analogs in state court decisions or state statutes. And so I guess that the question is, are we looking for an analog here? On the other hand, it specifically is a claim for malicious prosecution. And if opposing counsel's right, in this kind of catch-all statute here in West Virginia, even though there's 2 years for everything else, there's a carve-out for the 1 year. And the question is, well, I mean, is that still part of the default statute, or is it something else?
I think I put it back to, well, let me start here. We need to be careful about calling it a malicious prosecution action. That is something that we have done in our briefs, that courts have done in the past. However, this, under both Durham and Horner, They specifically state that this is actually a 1983 cause of action, and the variety of it is a malicious prosecution. It is not, we don't have a malicious prosecution federal claim labeled as such in the federal courts. We don't have a false arrest or a bad warrant claim like that. They are all 1983 actions, and they apply whatever the residual personal injury statute of limitations is for all versions of federal 1983 actions.
Well, one thing, if, assuming we have some additional briefing here, it'd be helpful to have some discussion on Section 1983 cases at large, where you do have a statute that's something like the West Virginia statute that appears to have a carve-out, so that we know whether the carve-out has any validity, or it's going directly to the original problem, that we're getting back into picking state court causes of action as opposed to a generalized 1983 cause of action. I don't know the answer to that, but I think it would be helpful in briefing to try to address that.
Certainly, and I understand why the court has some consternation about this particular argument and what we're presented here with West Virginia's statute, state-level case law, and how this court and the other federal courts are supposed to be applying it with a federal cause of action. I just come back to, this is a federal cause of action that has been pled. It's a 1983 action. It is not a state malicious prosecution action. Had this case been filed within the 1 year of the dismissal of the underlying criminal charge, then certainly both causes of action could have been brought, both the state malicious prosecution action and the federal malicious prosecution action. But it wasn't. That's not when Ms. Cooper elected to do this case. She elected to do it, unfortunately, after 1 year had expired, but before 2 years.
Well, you know, instinctively, I'd enjoy getting the views of the West Virginia Supreme Court. I was thinking, gosh, it seems like the interpretation of this law would benefit from the West Virginia Supreme Court decision. On the other hand, we'd be certifying in something that was brought as a federal cause of action, and it wouldn't necessarily, the certification response wouldn't necessarily resolve the whole case, which a lot of states would like. But it seems to me the interpretation of the whole state law would, assuming that Owens channels us into a question of state law on residuality. It'd be good to get the West Virginia Supreme Court's view on it, although I think certification is normally pretty awkward when you have a federal claim like this, and where if they said, well, it was a 2-year statute of limitations, that wouldn't resolve. I don't know what they'd say.
No, and I know I'm past my time, but may I respond?
Well, sure, you can, but I just, if they said, well, no, it's a 2-year statute of limitations, that wouldn't resolve the case. The case would just go on the idea that it was timely filed. But you go ahead, you wanted a chance to respond.
That's correct.
I'm glad to give that to you.
Thank you. And I don't think this, it's kind of like a bottom-up approach is the way that the federal courts have handled matters in the past anyways, especially on an issue such as this. I mean, we look to the Supreme Court, Court of Appeals, those get applied by the district courts. City of Wheeling is hoping that we take this bottom-up approach where we take district court rulings. Now let's create new law at the Court of Appeals. Let's create new law in the Supreme Court. That's not the way it works. It's the top down from the Supreme Court to the Court of Appeals to the districts. And, you know, something I'm reminded of is the statement at the top of the U.S. Supreme Court, and that's equal justice under law. That's what we're looking for here.
Okay.
Yeah. And I would ask that the courts, in the event that, obviously we understand if it decides to request supplemental briefing on the issue, I respect that. However, I don't believe that is fully necessary. Would ask that the courts reverse the district court's holding and remand for further proceeding.
All right. We thank you, sir. We will adjourn court and come down and re-counsel. I want to thank our courtroom deputy for a fine job.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.